Okay, we're gonna get started since it's 2:30. We are expecting a few other people, but we'll see if anybody else comes in. So, as Terry was telling you, this room is being video recorded for live streaming to YouTube. So now all DPS videos can be watched from home. We haven't we haven't advertised that yet, but we do have to let you know so that you know that the cameras are on. But basically, they're facing the speaker and not you, so you really can't see you on the YouTube stream. Um, we have all the handouts out there, and you should have received the evaluation, the bid opportunity list, but I think you already had one. And then the handout that Terry brought was an example of a bond, performance bond. So usually we always ask that everybody hold the questions to the end, but if you're the only one in the room, you can ask questions. But the biggest thing is that Terry has to repeat your question because the only way that they can hear it on the YouTube is into the microphone. So if you ask him a question, he's going to repeat the question and then respond to your question. So I will turn it over to Terry, and we'll see if we have anybody else come in.
Thank you. Oops. Okay. Good afternoon. Hello. Again, my name is Terry Glavin, and on behalf of the Department of Procurement Services, on behalf of the City of Chicago, Mayor Rahm Emanuel, as well as Commissioner Jamie Rhee, the Chief Procurement Officer for the City of Chicago, I want to welcome you to today's workshop and also thank you for taking time to participate with us today. We appreciate your interest in doing city business and specifically learning more about how to do business with the city. And toward that end, what I'm going to talk about today is an introduction to city bonding requirements and bonding issues. Now, I want to point out before we talk about city bonding that there is a list outside this bid and bond room. It's also available online. It's a list of Department of Procurement Services workshops throughout the year. And so in addition to this workshop, I encourage you to look at other opportunities to learn about the procurement process. Now, to understand the the bid requirements for the City of Chicago and the bonding requirements related to bids, I think it's important to get a little bit of context surrounding the discussion. And so I'm going to get into a little bit of detail about the procurement process, just very limited, because there is another workshop where I do discuss the very fine details of the fundamentals of procurement and doing business with the City of Chicago. But to give a little context to today, I want to talk about some of the general steps in the process for procurement that might be helpful. As I begin, though, can I ask what line of work are you in? Fantastic. Well, I encourage you, we have workshops that might be of interest to you related to, again, doing business with the city, procurement fundamentals, but we also have professional services related workshops that would be helpful to you. So you might want to check the schedule for that. Now, if you're going to participate in city business as a vendor, if you have already, you might know this. If you have not, it'll be important to realize that bonding will come up, and the details of bonding requirements are found in the law. They're found in local municipal code. They are also found in policies and procedures at the Department of Procurement Services, and finally, they'll be found in the solicitation or in the specifications for specific projects. Now, what's important to realize, though, is that sometimes the term bond or bonding is thrown around, and sometimes there's a failure to recognize the distinction between the different types of bonds that are required or that are used with the city procurement process. One type of bond is a bid bond. One type of bond is a performance and payment bond. So it's important to know the difference. In addition, it's important to know distinctions between bid bonds and bid fees or bid deposits. So we're going to cover some of those differences today. And as I had mentioned, pretty much everything we do at Procurement Services is governed by law. So as you think about these concepts, as you get involved in the procurement process with the City of Chicago, it's pretty helpful to become familiar with the laws that apply to the procurement process. So one law, which is worth looking up, and you can do it either at your local law library or you can easily do it online. One law is the State Purchasing Act, and the Illinois Municipal Purchasing Act for over 500,000 population is the statute that applies to us. So you could even Google 65 ILCS 5/8-10 and you'd be able to pull up the statute after a short search and learn a little bit about the state law that applies. Also, if you go to the Chicago Municipal Code, and an easy way to see that is by going to amlegal.com. That's AMLGAL.com. That is an online publisher of the Chicago Municipal Code. If you go online, you can look at 2-92. That is the section of the Chicago Municipal Code that creates and empowers our department, the Department of Procurement Services, and empowers our Commissioner, Chief Procurement Officer Jamie Rhee, with her authority to conduct the process of getting contracts into place with vendors so that the city can buy goods and services. So it's helpful, I think, to become familiar with the law that underlies everything we do, including bonding issues. Now, what is a bid bond? Well, before we get into talking about what bid bonds are, I'm going to talk briefly about the process that leads up to the need for a bid bond. Now, typically, under the Illinois Municipal Purchasing Act, contracts are awarded to the lowest responsible bidder. And what that means is that there has to be a bidding process. And typically that bidding process is through a sealed bid where multiple vendors submit sealed bids that are opened at the same time. And within those bids, vendors provide their, among other documents, they provide their lowest bid or their lowest price that they can give for a certain, typically for goods, but perhaps even for services like work services. Now, there's a process involved for us advertising to get those bids. There's a process for vendors to get their bids submitted on time and to make sure that those bids are responsive to our needs. And then there's also a time period that takes place after bids are submitted and open where we evaluate bids and make sure that when we award to the lowest bidder that it's to a responsive and responsible bidder. Well, during that evaluation process, the vendors that have submitted bids need to be committed to performing the contract if they win the award. And that's where bid bonds come into play. So bid bonds basically give us, it's a type of assurance that if a vendor submits a bid, that they are going to actually follow through if they win the contract. They're going to follow through and perform on the contract. And by law, what the city is allowed to do is to take a certain amount of time to evaluate bids, and once bids are evaluated, they award the contract. During that time period, vendors cannot withdraw their bid. And the distinction in part is made based on how projects are funded. So if there is city funding on a project, then a vendor who has submitted a bid has to honor their bid for 60 days. If they try to withdraw their bid within 60 days, or if the city tries to award the contract to a vendor within 60 days, and somewhere along the line the vendor doesn't agree to perform, then the city can take the bid deposit or bid bond and forfeit it for the amount on the bond. And so it's considered sort of a penal sum or a penalty for not honoring the bid. Now, if the city does not respond within 60 days on a city-funded project, then the vendor is free to not honor the bid unless there's an extension that's been agreed to. Now, if the project is federally funded, then the vendors that have submitted bids have to honor their bids for 90 days. So there's a little bit more time for the city to evaluate the bid. It's 90 days that the vendor has to honor the bid for the city to complete its evaluation process. After 90 days, the vendor can withdraw the bid, and the city will still return the deposit or the bid bond if the 90-day period is passed and the vendor withdraws after that. So it's important when you look at the advertisement and you pick up the solicitation or the specification documents, it's important to be mindful of what type of bid deposit is required and also what's the funding that's paying for the project. And that'll make a difference as far as bid deposits are concerned. Now, mind you, the bid bond is not the only way that we get assurances for bids. We can also accept certified checks, cashier's checks, and even money orders made payable to the City of Chicago. If you're wondering which type of assurance is appropriate for the project, just make sure you read the specifications. Because the specifications that are in the bid package that you pick up, when you're interested in the project and you pick up a bid package, the specifications inside will detail everything you need to know, including what type of assurance is needed, what type of bid deposit is needed. And just make sure you follow those requirements. And not just in the bid deposit arena, but just throughout the specification documents. Always read specifications from front to back, word for word, because remember I used terms like lowest bidder, that a vendor must be responsive and responsible. Well, those are legal terms. Those are not just carelessly used terms or off-the-cuff terms. Those are actually terms you find in the Illinois State Purchasing Act, and those are requirements on vendors that you be, if it's a competitive bid, that you be the lowest bidder, that you be responsible or presently capable of performing the contract, but then lastly, that you be responsive. Responsive means that you're going to perform the contract the way we want it in accordance with the specifications, right down to the way you submit the bid, including the right bid deposit. So always read the specifications. That's going to be your compass when you're preparing a bid for a project. Now, there's one last point I want to make about bid deposits or bid bonds. There is the occasion where a vendor makes a mistake. And the law and the Department of Procurement Services recognize that sometimes there's an honest mistake. So if you submit a bid, and let's say, for example, you submit a bid to sell certain goods to the city. And let's say the best price you can give the city, where you make at least an acceptable profit, but at the same time you're competitive in the sealed bid process. Let's just say your best bid would be $100,000. But by mistake, you left a zero off of your bid, and suddenly you offered to provide the commodities for $10,000. Well, that would be a real problem, right? We would be happy to receive that bid and award that contract and pay $10,000 for $100,000 worth of goods. But at the same time, what could that do to your business? That may not be a fair result based on a mistake. So if there is a mistake in your bid and you've submitted a bid along with a bid deposit, then keep in mind there's always the opportunity in writing. You can submit a request to the Chief Procurement Officer indicating there's been a mistake, explaining the mistake in detail, and then it's within the Chief Procurement Officer's discretion to decide whether or not to allow you to withdraw the bid without forfeiting the bond. And we, as a department, try to be fair, and if there's a good explanation, there's a possibility the Chief Procurement Officer may allow you to withdraw the bid. Yes.
So it couldn't be modified to say the waiver is supposed to have 0 there.
Typically, we don't allow vendors to modify their price. And you can imagine if the Department of Procurement Services were too often to allow vendors to provide an excuse and then modify their pricing, that could be a little problematic. Now, the Chief Procurement Officer has discretion in various areas within her powers created by law, created by the Chicago Municipal Code. So, really, I would have to say it really is case-by-case basis. So, in response to your question, can a vendor, if there's been a mistake, modify their bid price? The answer is typically no, pricing should not be modified. Now, there's oftentimes confusion, as I mentioned earlier, when there's a discussion about bonds. Sometimes the conversation is about bid bonds, which are assurances or security deposits on a bid. And then there might be a performance and payment bond matter that you're discussing. Now, a performance and payment bond is different. It's still an assurance. It's not, though, an assurance related to your bid as it's entitled. It's more of an assurance related to the performance of a project and then also payment primarily to subcontractors. So it's really an assurance to the city that basically the project's going to get done and that everyone working on the project is going to actually get paid once city dollars are being dispersed in response to payment. So when are performance and payment bonds required? Well, they're required for public work, construction, and improvements typically. They're performed for the city of Chicago. They can also be required in certain areas of work services. When that line of work is sort of closer to construction, public works, and improvements, work services sometimes can require performance and payment bonds from vendors. So keep in mind, those are the areas typically where performance and payment bonds are required. You'll never be guessing, though, whether one is required as long as I said, you look at the specifications. We say in our solicitation, in our specifications, that a performance and payment bond is due, if it is going to be required. And then also, what are the requirements related to that bond? What type of bond do we need? So, what's the amount of a performance and payment bond, and on what type of construction improvements or public work projects are they required on? Well, they're required for projects over $100,000 in value. And then once that threshold is triggered, then the amount of the bond is going to be the lesser of either $100,000 or 10% of the contract value. And I hope I explained that right. But basically, if the contract is over $100,000, start thinking the bond value is going to be 10% of the project value. Okay? So, yes?
So even for the small bids, like let's say if there are
So if
5,000, small bids like that, small.
If it's
contract work.
under $100,000, then there's going to be no performance payment bond that's necessarily issued. Now, mind you, performance and payment bond requirements, again, there's a section of the Chicago Municipal Code 2-92030 that you can look at amlegal.com, and that spells out all the requirements for performance and payment bond. And I'll read that section because I happen to have it right here. As far as the requirements, it says, the bond shall be for a sum no less than the greater of $100,000 or 10% of the total amount which the city is obligated to pay under the contract. And then at the top of that section of the municipal code, it basically says that whenever there's a contract involving the expenditure of more than $100,000, these requirements are triggered. So that sort of gives you an idea of when it's required. Now what I did hand out, and sir, I don't know if you were able to grab one on the outside. There's a handout. I have a sample performance and payment bond. Okay. And I wanted you to see this because it actually gives you an idea of what a performance and payment bond looks like. This is actually a city form. And if you have a project that requires a performance and payment bond, what you'll do is you'll go to a surety of your choice and have them use this form to issue the assurance in the form of a performance and payment bond. And this is the form they'll use. And this is the language we actually use on this form. Now, as far as the surety of choice is concerned, keep in mind that the surety has to be recognized by the U.S. Treasury Department on their Treasury circular. And it's very easy. If you go to the U.S. Treasury website, you can go into their search bar and you can search under surety and circular, and you'll be able to find the list of sureties fairly quickly. And you want to make sure that under the surety that you choose, that within that Treasury Department website, that they are able and recognized to work in the state of Illinois. Because not all sureties are recognized and able to work in every state. Now mind you, going back to surety bonds, bid bonds, if you use a bid bond, again, that's another example where you use a city form, and then that city form bid bond is actually signed off by a surety that's licensed to do business in the state of Illinois. So it's, in both instances, whether you're talking about bid bonds or whether you're talking about performance and payment bonds, you use city forms, but the surety of choice that grants the assurance, it's your choice who you go with, but they have to fill out our form and be recognized by the U.S. Treasury for performance and payment bonds, and both need to be eligible to do business in the state of Illinois to issue assurances that the city can use. Now, what's the context? Why do we need performance and payment bonds? So the first issue we're trying to cover is we're trying to cover performance, right? So what happens? Let's say we put out a bid for a construction project. Let's say to build some type of building for the city of Chicago. Well, the vendors come in, they all bid, we go with the lowest responsible bidder, everyone's happy. We begin the project, and then let's say the lowest bidder that we ended up contracting with has some type of financial stress, maybe spread themselves too thin among different public and private projects. There could be a lot of variables, but at the end of the day, let's say that the vendor can't complete the project. Well, what do we do? Well, the problem is if we were to go and try to dispute it with the vendor, whether it's negotiations, whether it's litigation, or whether it's just based on finance, that vendor will never be able to complete the project. What would happen? The project would sit incomplete, and the city can't have that. And that's one of the reasons why these requirements are here, so that we have a remedy. And our remedy with the performance and payment bond on the performance side is that we can then go to the surety that's signed off on the bond. And if you look at the form, in the caption, the surety becomes a party to this performance and payment bond. They execute this bond as one of the parties to it. And they basically agree that they're going to be assuring that this project is completed. And there will be a dollar amount that this bond will assure. And I want to make sure I say assure all the time, because this is not insurance. There is a distinction. On projects, you may still be required to submit insurance. For example, for accidents, for personal injury, and for other matters. Insurance is something different than an assurance that's provided by a surety for performance and payment. So just keep in mind you might have to submit both on certain projects, insurance and an assurance in the form of a bond. But let's say that project that's half complete, we need it completed. We then go to the surety and we say to the surety, we have this failed project, and there's different avenues we can go. We can ask the surety to complete the project by hiring contractors and getting it done. We might work it out with the surety where they simply just write a check for the amount on the performance and payment bond, and we might take that check and hire new contractors and complete the work, and then use that money to pay for those new contractors. So there are different avenues that we can go down with a surety, but basically this gives us a sense of security that a contract will be completed once it's started, and that we won't have to go back to additional city tax dollars, public funds, after we've already maybe spent some money. We don't have to go and keep throwing money at a bad project. We can go to the surety for the finance. Yes. We don't automatically go to the next low bidder. Again, there are certain rights the surety has, there are certain rights the city has, and also there's just some decisions that have to be made on a project-by-project basis. And sometimes the most cost-effective way is to allow the city to exercise its ability to take over the project and perform the work itself through its own vendors. And then sometimes, as I mentioned, the best way is to get the penal sum from the bond, take that money, and find the next vendors that can do the work. Now, mind you, there's various ways we can put the project back out. We can put out a new solicitation, perhaps. We can take over the project ourselves. We do have a rider in our performance and payment bonds that give us the ability to either let the surety complete the project, or we can retain control and perform ourselves. So we do have performance and payment bonds that allow us to get the best result possible under less than optimal circumstances when a vendor fails to perform. In addition to performance, though, the bond, as I mentioned, serves another function. Let's say on that same project that a vendor has started the work, and whether it's halfway done or fully complete, the vendor, the prime contractor, has submitted invoices for the work, and the city, in response, the project's been completed, we're satisfied, we pay the prime contractor for the work completed. We come to find that the prime contractor has not paid all of its subs. Well, there is a problem there, right? So what do the subcontractors do? The subcontractors have claims, various claims that they might be able to establish to try and get payment. They have certain lien options they might seek to exercise. And at the end of the day, when we have a project is complete, we want to make sure it's complete without any outstanding disputes or claims. And so if the prime contractor has failed to pay subs on a project, then what can happen is the surety can be responsible for paying subs directly under the payment portion of the bond. And then the surety can maybe go after the subcontractor, the prime contractor, to be reimbursed. And there's various remedies that the surety has, but at the very least, the city, again, does not have to go back to its funds, especially after it's already paid the prime, and then risks spending more money to try and resolve the disputes without any guarantee that it's going to be able to get all of its money back as soon as possible. So again, the performance payment bond is an assurance, and this portion of it, the payment portion, makes sure that the subcontractors are paid. Now lastly, what the performance and payment bond does is it has a section that covers workers' compensation, and it's pretty self-explanatory because that's spelled out pretty well in the performance and payment bond sample that I gave you, and basically it covers any outstanding workers' compensation issues that there may be. Now, if you are asked to submit a performance and payment bond, keep in mind that you want to cross a few T's and dot a few I's. Why? Because if the bond comes in and it is in some way technically not complete, we typically can't award the project because the performance bond and payment bonds are a requirement. And so it can delay a project or a contract award if all the T's are not crossed, I's dotted. So keep in mind, there are a couple things that jump out in my mind as far as what can go wrong with submitting a bond, a performance and payment bond. A few of the things we commonly see are someone signs the bond that doesn't have authority to sign it. So we typically look for the president of the company and the secretary of the company to sign off on the performance and payment bond for the vendor side. And then usually sureties have a local attorney in fact that they empower with the ability to sign on behalf of the surety. And then when you have the vendor signing with the proper individuals and you have the surety signing with the proper individuals, you want to make sure that it's notarized, and there's a form, notary form attached to our sample. You want to make sure you have a notary that's current, sign off on, attest to the signatures of the vendor and of the surety. Any of those missing items can cause a holdup. We have to return the bond, we have to make sure everything's complete, so I encourage you to make sure that that's all complete. Also, whenever you're submitting for a project, and this includes for bonds, but just in general, make sure your status or your standing with the Secretary of State is in good standing, that your company's in good standing. And mind you, there's a number of reasons why you might not be in good standing. It doesn't mean you're necessarily a bad company or that you shouldn't be authorized to do business, but it could be something as simple as you didn't complete your annual filings or you didn't complete your annual fee payment to the state of Illinois. And so just inadvertently, you've ended up in less than good standing with the Secretary of State. Problem is then we struggle to award the contract. So I encourage you as vendors to periodically check the Secretary of State website for your status. And then also, especially when you're about to submit a bid, it's a good idea just to make sure that you are in good standing. With your bid, we also are going to check to make sure you've submitted proof of insurance for that contract. Now, insurance is, again, different from an assurance provided by a surety. And insurance is more for liability, as I mentioned, typically like personal injury and other forms of liability. You need to submit an insurance face sheet that proves that you have the right insurance. Now, what's the right insurance? I can't tell you today. And the reason being is it's project by project. So go to your specifications, and the details of what type of insurance you need for each project are in each project's specifications. But make sure you have the right insurance submitted at the time you submit your bid, and especially around the time that we're reviewing performance and payment bonds for you, because it's part of our review. Make sure the surety that you're using is in fact recognized by the U.S. Treasury. So you might want to look that up just to make sure that they are eligible to issue assurances within the state of Illinois. Oops. And one last thing I want to point out is, and this is again not specific just to bonding issues, but this is in general for city contracting. We will also check, when we review bonds, your economic disclosure statements. Are you familiar with what economic disclosure statements are? Okay. By law, we require certain information from vendors whenever we take some type of action, like award a contract. And one of the main disclosures is that whenever we do business with a vendor, that we get a disclosure of ownership of greater than 7.5% interest in the prime contractor, ownership or beneficial interest. So that's one of the disclosures. But there are many additional disclosures. And these disclosures are actually required by state law, and many of these disclosures are required by Chicago Municipal Code. So it's not as though we just make up these disclosure requirements. It's not as though we are just asking questions just because we're nosy. These are actually legal requirements. And so we can't award the contract unless EDSs are complete. So go online. Economic disclosure statement forms are online. So if you go to cityofchicago.org/procurement, you'll end up at our webpage, and there are links to the online EDS form. And mind you, you don't necessarily have to have a project to get started on the EDS. And what you don't want to do is have it where you have a project in mind, you're ready to bid, time's running out, and then you still haven't done your EDS yet, and you've never looked at it, and it takes time, right? So I encourage you to get started right away and get your EDS, at least get familiar with, right? Log in, get familiar with it, and then that way you can quickly get it done if you're not going to do it right away, or if you have questions you can ask before your back's against the wall on a time-sensitive project. So I encourage you to go to the EDS. Yes? Annually, there's a requirement that, well, there's two ways to look at it. One is if there's changes in your circumstances or in your answers, then you have to immediately update your EDS with the city. Now, you know, within a reasonable time when I say immediate, but you should get on it right away. And then secondly, there's an annual requirement that you provide a no change response. So that EDS is always required. Now,
If you've already provided that period, then we
if you're bidding on a project, even if you've already provided, because there's an EDS required for each project. So regardless of being certified as an MBE, WBE, DBE, you have to have an EDS completed for each project. So make sure that you're up to speed on that and able to do it. And those are generally the items that we're going to review when we are looking at bid performance and payment bonds, bid deposits, bid bonds. And I mentioned earlier, keep in mind there's one other thing. It's not a bond, so it's not really part of this workshop, but just in case you see it, I want to make sure you're aware of this distinction. Some projects have a bid fee. And now a bid fee is separate and apart from a bid bond. A bid fee is something you don't get back. A bid fee is a fee that'll be included in the specification, so you'll know it's required. If you fail to provide it, if it is required, then it is something that can be a basis for rejecting your bid. But it's, I don't want to say, well, yeah, it's rare that we have a bid fee, and it's usually for extremely large construction projects, where the evaluation of bids is going to be lengthy and intense. And so oftentimes there's a bid fee involved in that process, more or less to defer the expense of the evaluation of bids for a very large project. Typically we don't have bid fees, so it's not something necessarily that you're going to have to worry about. So those are the bid deposit issues, performance and payment bond issues. What I'll do now is, I know you've been asking questions as we've moved along, but I'll open it up. If you have any particular questions, then I'll be happy to respond. What I'll also do is provide you with my contact information as we close out. And that way, if you don't think of a question now, or you'd prefer to ask me your question by email or by phone, I'll make that contact information available to you. I'll also stick around afterwards in case you have any questions. But while we're here, is there anything that you have in mind, any questions you have outstanding?
I have a plan for U.S. Customs and stuff like that. Typically get it through insurance companies or state products. So that's kind of what we're talking about.
It is most likely going to be the same type of company that can issue this type of, our type of assurances, but the bonding you're talking about is going to be a different bond. In other words, you can't take that bond and use it on any of our projects, but, right. I would venture to say it'd be a good idea, since you have a relationship with that surety, to go to them and see if it's a line of product that they offer. Again, not every company, and you know this, I'm sure from your business experience, not every company offers every line of assurance or insurance. Sometimes they're selective. There's just certain lines that they specialize in, or certain industries they specialize in. Some sureties may prefer to do public work or private, or do both. So I would contact your surety and see if they offer it. Okay.
But I have one, I apologize, it might be because it isn't late, but, so, let's say I submit a bid for goods. You saying that I have to hold to the contract, those terms for 60 days? I think I have to hold for the term of the agreement.
And the question is how, if you submit a bid for goods, how long do you have to honor your bid, is the question. And I will specify, if it's city funded, in other words, we're not using any federal dollars to pay for the project, then it's 60 days that the vendor has to hold firm. So when you submit your bid, you said you were under the impression that you had to sort of indefinitely honor your bid, and that's actually not true. Well, okay. Now, once you're the winner, then you have a contract with the city, and then you do have to honor that through the life of the contract, which will be spelled out in the time period of the contract. So, yes, you have to, once you've been awarded the contract, you have to honor your bid through the life of the contract. But prior to award, while we're just trying to decide who the winner is, you only have to hold or honor your bid for 60 days if it's city funded. After 60 days, you can actually step back and say, well, I'm bidding in Milwaukee, for example. I'm gonna go do business with Milwaukee, and there's no basis for us to hold your bid deposit. Now, on the other hand, if it's federally funded, it's 90 days, and you're sort of free to go after 90 days. If within the 60 days for city funded or within the 90 days for federally funded, if you try, I guess, to back out, then we take your bid deposit or your bid bond and we forfeit it. And that's sort of the penal sum for not honoring your bid. But that's basically how it works. Okay. Okay. All right. If there are no other questions, I'm going to give you my contact information. Again, my name's Terry Glavin, and you can reach me either at my email address, which is terryglavin@cityofchicago.org. The number where I can be reached at my office is 312-744-0851. If you have a question, if you need a resource, I can help you find resources at the city. If I'm not the best resource for you, I'll try to connect you with the best resource. And in addition to questions or resources, if there's a form or anything that you need, I can respond by emailing you information as well. So again, I appreciate your time coming in today. I hope you enjoyed the presentation. Look at the workshop schedule for additional workshops, and otherwise I'll look forward to seeing you do business with the city. Have a great day. Thank you.